It's been less than a year that I've known you guys, and what I've seen so far and learned and attending these webinars, if I would have had an inkling of what you guys are teaching back in the beginning, reserve your rights right from the start. Do not give them up at all. No compromise. There's no reason to. It's all right here with what Sherry and Ron are saying.
Yeah, so you've got to get this resolved as quickly as possible. If I had known these techniques that I just brought to you guys in the last 2 webinars alone, I could have reduced the time that this was going on, and one of my children wouldn't have aged.
This is what people need to do to change what the system is doing to us and our families. It's very important
for your children.
Yeah, because your children will be very relieved if they find that you've got this fixed and they're no longer being used in the middle. Well, I wanted to welcome everybody for coming tonight. This is called What is the Voice of the Child? When we're addressing these issues about children, child support, alimony, missing time with your child, it seems that there's a different set of rules for people that are in divorce or people that have a relationship that's ended. And so I made this little note that it's not that they shouldn't be handled individually, because a lot of people think that because we are giving them a basic foundation and a general set of rules, that we're saying that things shouldn't still be handled individually. They are handled individually. It's just that now the proper procedure and due process is being applied so that people aren't being disadvantaged improperly, and also so that people aren't being cost excessively unnecessarily. So that everyone should be following the same set of rules, and those rules should be applied equally, even in divorce. I'm your host, Sherry Palmer, with FixedFamilyCourts.com. We are the author of a couple of books. I'm also a parental rights strategist and a constitutional scholar. Ron Palmer, who you'll see in a little while.
Hello, guys.
They can't see you right now. Oh. I'm on the slideshow. But Ron Palmer, he was sitting beside me. He's also the author of the 2 books, Parental Rights Strategist, Constitutional Scholar. He's also a business strategist. So what are we covering today? It's how to cut through the confusion regarding a child's voice. What is the real voice of the child constitutionally? So I'm not saying at all that I'm speaking for your individual child. What we're saying tonight is that we are speaking on behalf of children's rights constitutionally, and we are not lawyers, and we don't practice law. So remember that any of this information that you use, just a quick disclaimer, is at your own risk. Please check it. Please make sure that it actually applies to your specific case. Only you have all of those details. If you need assistance or help on that, you can contact us at www.fixedfamilycourts.com or email one or the 2 of us, which I'll type into the chat later for the email addresses. Okay, so we're talking about what are the rights of the child constitutionally. We're talking about also child support and alimony and how those relate to all of this. Did you ever think this could happen? Because the first thing we have to address is emotionally. Did you ever think that you hadn't done anything wrong, that there was no way you could lose your children? Or did you ever think that a judge would ever entertain the other person's claims without ever proving them? As we're going to go over claims of abuse, we're going to go over the difference between claims of abuse and also charges of abuse. And did you ever think that joint custody could mean that you still might not get any time or hardly any time with your children? Many of you have that, and yet they don't consider it termination. We're going to go over, did you ever think that your child's voice would be used against you? And that also includes when you feel it's an advantage to have your child's voice heard. Okay? So ultimately, by the time we're done with this presentation tonight, we will show you how to not let your child pay the price anymore in this process and this system. So the voice of the child, what is it? Do you feel like it's being used against you? Do you feel like it isn't being heard? You're not able to protect your child? And I'm using singular, so if you have more than one child, this applies, of course. Do you feel like you cannot get anyone to protect your child in divorce? Do you feel attacked for trying to be with your child? All of these things you might have as questions. So please let us finish the presentation, because we might address your question. We might answer what it was that you wanted to know. What are some of the biases and prejudice regarding the voice of the child? We're going to cover this first, because I think our biases and our prejudice get in the way, and it makes us interpret certain things as being the voice of a child when they're not. Because sometimes our feelings or how we think life should be for the child, we start to think that that is how a court system should view your child. Hopefully that makes sense by the time I get done. But we tend to believe, and the courts have passed policies that state the child's old enough to decide in divorce, right? But when we really stop to think about this, why is that the case in divorce but not in marriage? And that's not actually the question we're going to completely go into depth with. I just want you to think about that the child is old enough to decide in divorce but not in marriage, which also leads to many times I'm hearing children say, and I have actually, I've heard children say, you and Dad got divorced, so now we're divorcing a parent. Some children actually think that way. They think that's the way it's supposed to be. So in divorce, however, the state believes they can take over the decision making. They don't necessarily believe this in marriage. So there's a complete perspective shift when you go through divorce with you and with the state. And I call the court, the family courts, the state, because that's really who they are. Many times in divorce, they're acting on behalf of one of the parents, whereas you'll find in criminal cases, they're acting on behalf of the state, even though there's a victim that they're representing. And you'll find that this shifts into that phase when a parent's ordered to pay child support, because all of a sudden the state will step in now and say they are representing the state, that they are bringing an action on behalf of the state. And we'll talk about that in a little while, because it's important to understand these shifts. When you don't understand the shifts, you get knocked off balance in these situations, and you're already emotional. You're already feeling that you should only have to worry about your child and not have to worry about all this process, especially if you've hired an attorney. Then you wonder why you're not feeling more protected. And hopefully some of this presentation tonight will help you understand that as well. So the other bias that we get is that the child should be able to choose whether or not they want to be with one of the parents, right? We're trying to keep this gender neutral because we're not biased towards mothers or fathers. But you could say either way, child should get to choose whether they want to be with their mom or want to be with their dad. But in marriage, I don't think that most of us felt that way. Maybe not as long as you were getting along, but in marriage you certainly couldn't go to the court, I know not in Texas, and ask them to give you the child over the other parent while you were married. They would tell you you both have equal rights, that both of you can do what you want, unless you get divorced. And later, probably in other presentations, we'll talk about that too. I think there's a lot of these divorces that, I'm not talking about the ones that are real abuse and narcissism, all that, but I think other divorces sometimes inflame and possibly could have been prevented if they had not been told that they couldn't get their individual rights protected if they weren't in divorce. So that's another topic for another day, but just something for you to put on the side to think about how that might actually contribute to more destruction of relationships and divorces. So the last one on this slide is the court can order evaluations and tests of the child and the parents in order to keep the child safe. Remember, these are biases and prejudices. We are not saying that this is actually the proper authority of the courts in divorce. But that's what they feel. As soon as the parents are in conflict, that you can go to them and ask them to do evaluations and tests, or they can order that on their own, which many times we are calling sua sponte, orders from the judge. If the judge feels that it's harmful for the child to be around parents that don't agree, then they automatically can order. And some of them do this just as a routine now. They'll order psych evals. In California, I think it's 730 evals for family studies. In Texas, they call them home studies. Different states, they're called different things. They'll order parenting coordinators, gals, different child representatives, all sorts of people that come in between the decision-making authority of you as the parent and the child. Now, sometimes in the beginning, you may think, wow, what a great idea. I don't want to deal with that jerk anyways. So I'd much prefer this other person gets involved, and they'll see what a jerk the other person is, and surely they will make them change. Or they will make sure I never have to deal with that issue again. And that's not generally what happens. In fact, many times, as many of you know, that if you are dealing, I don't like to say labels, but this is the way we identify with things. But if you do have someone that you're trying to get out of your life that has been a narcissist or is displaying narcissism, you know then that many times they're skilled at manipulating other experts. And sometimes they also have connections, and not just narcissists, but let's say that they happen to be in the law field themselves or in the police force or, you know, somewhere where they all kind of interact with each other. Then you see that collusion and that, you know, that bias towards one side behavior going on, etc. So that's a very dangerous way to think and to let your rights to your child be controlled. And if you thought you were going to get out of the control of a narcissist, the way to do it is not through another expert or even telling the states they need more training to identify narcissism, because you're never going to find perfection in that. And you're going to end up having that cost put onto you, the parent, because the state is not taking on these costs with parents. The state only takes on the cost when real criminal charges are being filed, which is one of the issues that we bring up, is that if you file real charges, like if you have claims of abuse and you don't file them as charges and you just want to take them through the family court, who does it cost? It costs you. It costs you to pay the attorney. It costs you to pay for the investigations, the discovery, and then you're dealing with a court that can be manipulated and biases and prejudice come into play. But when you put them into a different form, which is criminal charges, and I understand this system's not perfect either, and they may refuse to take those charges, then you're ending up in a situation where you're not necessarily paying to have the prosecution done, but you may end up being denied a prosecution, right? Okay, so we're going to cover some more of this. Let's go to the next slide. First, we got to talk about what are the rights of the child. And we have a page on Fixed Family Courts. I'm going to pull that up. Ron calls it CRUBIS because it's child rights under the best interest standard. So if you want to note this page down, then you just put in what you see at the top, fixedfamilycourts.com/CRUBIS/. This is the rights of children. This is a free page under the best interest of the child standard. And Ron wrote this up so that everyone can go to one place and get the same definition. And he talks a lot about second-class citizens, but we haven't talked a whole lot about second-class children. And I know some of you may be highly against equal rights for the or equal time for the children because of the abuse that you've been through, or even the abuse that the system's putting you through, and you may feel that they're missing, you know, mental health issues and things like that with the other parent. Again, we're talking constitutionally, so while some of these things that we talk about may sound like they're not great or something that you may want to use, research it a little further, because I'm finding more and more parents that spend a lot of money trying to prove the other parent is a horrible parent, and they still end up not having time with their children. And in fact, sometimes they end up being the one accused for alienation and other things, and the children end up even more time with the parent that you didn't want them with in the first place. So I really implore you to consider this as an option, that and through our research we found that actually it is the rights of the children to have access to both parents. Which leads me to, if you're going to try to deprive a parent the way to do it would be to prove them unfit. Now, proving unfit is very, very difficult, so unless you really have charges that they're unfit, these would be charges that the state would bring against them. So if they abandoned your child, they've committed child abuse, they've committed domestic violence against the child, those kinds of things the state prosecutes. Now, if you don't have the evidence, or if the state has denied your evidence, then you're probably going to be better off ensuring that your equal rights are protected. Okay? We can't make up for the system not being perfect, but we can give you this information. So the right to association is bound up within the First Amendment, right? Not only you have First Amendment rights, but your child has First Amendment rights. These are fundamental liberty interests. So if you read down a little further down the page to this second arrow where it says a federal appellate court has found that this right to familial association may not be denied to a father or his children. It was a father. Different cases are studied by different courts, and so we just pull pieces from them to demonstrate your rights, and so you can cite authorities. Okay, so this one says may not be denied to a father or his children just because that father was convicted of sex offense unrelated to the child and protected this right at the strict scrutiny level. Now, that might at first make you flinch because you'll say, oh my gosh, he was convicted of a sex offense. But think about this for a minute. What if the sex offense was that he was 24 years old and he was dating his sweetheart when he was in high school? Maybe he was dating a girl in junior high, and now they're still dating, and you know, one of the parents get mad at him and he ends up getting convicted for a sex offense. That could be one, they'd call it a child sex offense, not necessarily to their child, but so what I'm saying is not all offenses that sound offensive are as offensive as they may appear. Okay, so kind of let yourself absorb these rights and not get too inflamed about what cases are being used about the rights. So the next thing is the court has ruled that creating second-class children through bastardy laws based on nothing more than the child's marital, well, actually I should say the parent's marital status, is an impermissible violation of equal protection. And we have that page up there on this website, same place, fixedfamilycourts.com/rights made simple, and there's some dashes in there. So if you need that page, go to the main page of Fixed Family Courts and click on the tab above that says Equal Protection. Oh, right here. Click on Equal Protection, and it'll take you to the bastardy law arguments, so you can use those. And by the way, you can cut and paste things from these and put them into your motions and your pleadings and help support some of your arguments. Go down to the next one. The court has found that denying parental rights to a fit father because he was not married to the child's mother is an impermissible violation of equal protection. Now, again, the reason this one's about a father is because mothers have almost automatic protection to their rights. Mothers are not questioned as to whether or not they are the child's mother, because it's a little difficult to deny who the mother is. We know who the child's born from. Whereas a father, if he's never been married to the mother, and even sometimes when they are married, they're not sure, but if they've never been married, then there's a process they have to go through to establish paternity, which we're not going into tonight. But that's why this case got brought before them, is because a father was being denied those parental rights, and he was the biological father. And so, anyways, you can go through this page on your own and find out more of the child's rights, okay? And that will help you reframe your perspective and highlight maybe where some of your own biases or prejudices might be getting in the way and costing you money in the family courts. So it's not that you can't fight the cases or fight in the court the way that you want to. If you want to beat up the other parent, you want to prove you're the better parent, you can. We're just saying that's an expensive route. We're trying to give you a less expensive route. And we're just saying that may not necessarily actually be protecting your child. It may actually be hurting you, and hurting you could be hurting your child. It may also be hurting the other parent, and that may also be hurting the child. So the next slide. What if there's concern about harm to the child? We've kind of touched a little bit on abuse, right? Abuse and the way it's handled in family courts, though, are different than the way abuse is handled if you were to bring a charge and you were still married to the parent, or you're married to the parent and somebody else brings a claim, correct? So claims of abuse versus charges of abuse in family court is completely different. If somebody brings a claim of abuse against either of you parents while you're married, the court requires a very strict process in order for somebody to actually, I don't know if they call it indicting you, but to actually bring charges against you. They make them do it in a certain limited amount of time. Each state has their own fashioned rules and codes around this. And if the charges aren't enough, the claims aren't enough to bring proper charges, they throw it out, right? Now sometimes, and we've heard this before, that Child Protective Services will still try to keep their nose in there, and they will try to get parents to do service plans and things like that. And a lot of times the parents do it, a few months go by, they're done, and they're out of their life. But sometimes they do it and opened a door where they didn't have anything, and now Child Protective Services picks on something they didn't quite like, and you could end up losing your children that way. So I'm not saying you don't ever lose them in marriage. What I am saying is in divorce, parents seem to open that door every single time. As soon as a claim of abuse is brought, so many times either one of you will say, I have nothing to hide, go ahead, strip my life, look at anything you want because I'm a good person and I'm going to prove it to you. And that opens the door to excessive abuse of power, lots of costs and expense, and many times when you're trying to do that, maybe you're bringing the claims of abuse and the other side is saying, okay, you know, I'll go along with this, but they're applying it to you as well. So now you've got the same risks that are put on you. So even if you are a good parent, maybe now if you were dealing with a narcissistic parent, maybe now they can twist it on you, right? Remember that manipulation stuff? So think twice before you open this door and even make claims on the other side. And I understand, you know, your priority is to keep your children safe, but your priority is also to make sure that you are also keeping yourself whole and that you don't get stripped of all of your resources. So, you know, it may be wise that you find a way to get better evidence before you bring charges through family court so that you can actually get the proper authorities to take the charges. Okay, now repeated abuse of claim. So what happens if somebody makes a claim of abuse against you and they get thrown out, or they're unfounded, or they say it's totally not true and they're completely cleared, and then they bring a claim of abuse again? This happens many, many times, and now you're being restricted from seeing your child, right? We're going to talk about that in another couple of slides about how you might be able to handle some repeated abuse claims. We have many parents that we've talked to that are going through this, and it is not good. I can tell you right now, it is not the best idea to give in and open up your life to their inspection. Okay? So we're going to give you some ideas on what is better choices and how those can help shut down the empowerment of those repeated abuse claims. And harm to the child. How is it defined in divorce, in marriage, and constitutionally? And here's where I'm going to bring Ron over in a second here. In divorce, we tend to, ourselves and the courts, tend to define harm to a child different than we define it in marriage. In marriage, harm is defined under the child protection statutes, right? The statutes that the state is held to and Child Protective Services before they can step in and remove your child from the home, before they can terminate your rights as a parent. So harm to a child is under child abuse, child neglect, so you can't beat your child, you can't not feed them, you can't not clothe them, you have to provide them with basic needs, and you can't neglect them, but it has to fall under the definition of neglect. They don't get to make up a new one in marriage. But in divorce, they tend to lower those standards, and all of a sudden it becomes what one of the parents decides it is, and the state will buy into that and say, yeah, I think that is a better parent, and so they don't actually ever say it's abuse, but they kind of follow their path to power that they should only have if they have a proper claim of abuse or unfit parent. They invoke that power through complaints where they've lowered the standards, and you're not defending that standard. You're not fighting to have that standard maintained, and you're letting that standard get lowered, and you're in fact sometimes agreeing to whatever process that they ask you to go through. So constitutionally, Ron, how is harm to the child defined?
Well, there's a concept that comes out of the First Amendment called clear and present danger, and that's been incorporated in terms of harm to a child. The Supreme Court's used that terminology in terms of harm to a child, that there has to be clear and present danger of harm to the child. That changes the standard a little bit, right? It gives you something a little more concrete to get to. The danger can't be vague, it can't be uncertain, it can't be unclear, and it can't be somewhere off in the future or off in the past. It has to be clear, and it has to be in the present, right now, or in the immediate future. So that starts to narrow things down a good bit. There are other situations where this concept of harm is kind of vague, and we're hoping to see more challenges against this concept so that we tighten this up.
And here's something that I see a lot. I see parents being subjected to a mediator or some other person that they appoint to speak for the child, and then they decide that certain decisions the parent's making or feedback that they're getting from the child is that the parents are in such disagreement that they decide that that disagreement's harmful for the child. Is that in the definition of harm to the child, that a divorce or disagreeing with the other parent is considered harm to the child?
Certainly not. No, the Supreme Court's never said anything like that. And it's clear that parents in marriage disagree all the time. They fight. Many families fight all the time, and the state doesn't come in and try to take their children from them. So that's simply not appropriate. And beyond that, the best interest of the child standard does not give them authority to assign someone to basically remove your rights and grant them to some third party just out of the blue. That's a misconception of what the best interest of the child standard is and how it's supposed to be applied.
Right. Okay, so that gives you a basic definition, and if you want to know more about how harm to the child is defined, then shoot us an email at info@fixedfamilycourts.com. We'll direct you to sections either in our book, or we can direct you to anything that we've written on our website or elsewhere, so you can get a better handle on that, because they will insert people into the process who will misinterpret harm, and so you need those authorities to back you up to say, no, that's incorrect, that is not harm. Although it is a type of harm, it is not the kind of harm that the state can reach into. And we've discussed in past webinars, there's all different sorts of harms your child will go through. They go through changes in their life every day, with friends, teachers, different disputes or disagreements at school. They go through harms when they, start a new school year and they have to adjust to new teachers. All of that could be considered harm. They go through harm if you develop a new relationship and that relationship causes some tension, or and those are all harms the state really can't step into, and the child has to learn to cope. And in fact, you'll find studies showing, and we don't like to refer to studies for court use, but for your own emotional comfort, you will find that they do say children who learn to deal with diversity and different types of stressors, they build tools and they're able to cope better in life as adults. So let's move on to the next slide. What are some of the biases and prejudice regarding alimony and child support? First of all, you need to understand where your biases came from. Now, we're not going to read the whole thing about it, but if you want to read more about where I believe some of the root of it comes from, you can start on this Wikipedia page. It's about the Protestant work ethic, And this is where I think some of us, start to develop, first of all, we developed our idea of duty and obligations to the family regarding the man from this work ethic. And that's, in a lot of ways, it was great for society. But our societies have changed a lot. We now have more equality with men and women. And you may say, but the father or the mother agreed that I get to stay home and raise the child. And now we're in divorce, and that agreement should stay in place. Not so constitutionally. So I'm sorry if that upsets some, but constitutionally that would prohibit a person from getting a divorce and making different decisions. Now, that's not saying they get to erase that they have a child or erase that maybe you need a transition period. That just means that these ideas and these notions that we get to charge them for the rest of one of your lives, and that they have to maintain somebody, or you have to maintain somebody at the level that you lived in your marriage, we believe is unconstitutional. So some of your biases and your prejudice that go along with alimony and child support could root from there. Also, you may believe that disagreeing with the other parent because it created harm to the child, that it authorized the state to step in and restrict that parent from the child, and now they should pay more because they just restricted that parent from the child. But I'll tell you something, if that parent did not want that time removed from them, then that state, constitutionally again, never proved that the parent failed to support that child. And we believe then they are not authorizing child support properly. Because to make a parent pay to support a child before they prove that that parent is not going to support the child, while the state will claim that this is more efficient to not have to prove that the parent didn't support the child. And as a parent receiving support, not myself, but if one of you are, then you may think, oh my gosh, this is awful, because then what am I going to do month to month while I'm trying to prove the other parent isn't supporting the child? Again, constitutionally, we're sorry, you can't skip steps because it might be more efficient for the state to impose something and not follow the proper procedure. Because what happens if the shoe's on the other foot? What happens if you're the one that's being hit with child support? Or what happens if there's a federal statute like Title 4D that might entice the states to award child support to one or the other, but they want to restrict the time in order to justify it? I don't think you really want to be authorizing the state to do these things. So our claim is, our belief is that if you start holding them to the proper standards, one, that Title 4D that's disadvantaging a lot of parents in their mind, it's going to restrict and limit them using the excuse of restricting time from one parent or the other, because you are holding them to the standard of prove that I failed to meet my parental duty, correct? So how can they invoke Title 4D based on I've taken some of the time away and now we have to force you to support your child? How do they justify it? But parents aren't looking at it this way, and their attorneys aren't looking at it this way. When you start looking at it this way, I'll tell you what, it infuriates the courts, it infuriates a lot of the attorneys. And if you're dealing with people that are getting infuriated, it's probably because it's shocking the way that they are used to handling it. And that means that, yes, you are going to have to be able to withstand their intimidations and their bullying to get you off that path. But once you understand this, you know how to stick to it, and you know how to deal with those attacks back on you. And that's something we'll try to touch on in a little bit here. If you cannot get along with the other parent, you cannot make good decisions regarding the child, right? We've already gone over that. We know that's not the truth. That just means you two don't get along. The child's life shouldn't change in divorce. Okay, maintaining status quo set by decisions made in the marriage. Those are all biases that are leading to decisions regarding alimony and child support. If you do not learn to get past those biases, you yourself could be stepping right into these paths and these patterns. You also may not know how to explain that you are not giving up a right to the child, because a lot of courts will say child support is the right of the child, right? Well, what they're leaving out is the child being supported by each parent personally is also a right of the child. So you notice how they're stripping part of your rights to justify getting to the end that they want to get to, which is where they are in control and you have been stripped of your authority. Okay? So that idea that there must be a primary parent, totally false. There's no primary parent when you're married. It takes two parents to make children. You're both a primary parent to that child when that child needs something from each one of you. So family is only nuclear is one of the biggest biases that creates a lot of these rules and systems that got put in place that are unconstitutional. We tend to see family as the biological mom and dad and the child. Okay, that may be how a family starts many times, but that is not the only definition of family. Family might be just you and your child. What if the other parent dies? Are you not a family? So for some reason in divorce, we develop these blinders that all of a sudden wouldn't make any sense if we started to come out of this bubble of divorce that divorce puts us in and apply it in other situations. If the other parent died, you would not say you and your child was not a family. So same thing goes in divorce. When you two get divorced, each of you are now that child's family. That family can have many families. Is there a constitutional balancing test when considering alimony and child support? We're going to have to hurry through this because, like I said, we try to pack so much in. You'll have to read this slide. So if you need the information right away or you want to discuss the balancing test because you're facing something immediately, please email me so that I can talk to you privately, or I can, again, direct you to something else that's written about it. But the United States Supreme Court has found that the degree of due process required by the state to perform a balancing test means that they have to look at risk of error. And I know you might not have heard some of these terms, and we've gone over them in other webinars as well. We also go over these in more detail in our classes and our labs, which we'll mention at the end here, so you'll know how to look those up. Risk of error means that they take the kind of right that you're dealing with and they weigh the importance of the right and how much due process they need to apply to prevent an error in a decision made by a judge. Because judges are human. They know there's going to be some bias and prejudice. So if you're in court and you're fighting over, let's say you're fighting with a stranger and you two are saying one or the other owes money, you see that in small claims court a lot, they're not going to use a high degree of due process because a mistake in the decision just means that one of you leaves with a little bit less money. But a mistake in the decision regarding your rights to your child or your child's rights to be with you is a tremendous destructive error if a child and a parent lose each other in their relationship. So the due process for that should be one of the highest. But unfortunately, in divorce, they try to sweep that under the rug by saying they're not terminating your rights. Do not let them do this. There is a balancing test that gets you to strict scrutiny that they still need to use. Okay? Also, look down at the third thing on here. Like I said, if you want to know more about the balancing tests, contact us. The state is in this instance violating its own public policy in protecting the best interests of the children if they impoverish either of the parents and if they make it impossible for them to directly financially support them. And the case is stated there, Matthews versus Eldridge, that's from the Supreme Court in 1976. So when you start looking at child support, you need to make sure that if you are the one asking for it, that the numbers are correct, that you've proven that the parent has refused to be with that child, doesn't want to be, you know, all those other things, the fitness and all those things. Put them into place and make sure that you're not creating a situation that's going to hurt that child by impoverishing the other parent. Now, that doesn't mean, hey, the other parent doesn't work consistently, therefore they shouldn't, be equally responsible for their child. That means that the state really is not looking out for the best interest of the child if they're entering orders that are incorrect and ignoring parents that are trying to get justice on that. I know that Tina knows what I'm talking about with that. Yet they may take you into an enforcement hearing and claim that they are acting on the best interest of the child. Nothing more infuriating than that. So just keep that in mind for those of you that are trying to also fight improper child support, that they are not allowed to impoverish you, okay? Custody evaluations, challenging and using them. We're not going to go into detail on that, but we do teach information about those things, so I wanted to just let all of you know. We talk about what is custody evaluation, who conducts them, and there's an Ohio bar page that I pulled up that not to pull it up to get what's constitutional, but just to look at what they claim is a custody evaluation. So if you're in that state, pull it up, know what they think it is so that you know what to use constitutionally to bar them from using some of what they think they are allowed to do. Okay, but you need to know what they think. So look up the bar associations in your states. You just might find that they have some of these provisions there that you need to be aware of and you need to protect yourself and your child from. Custody evaluations I see as no different than psych evals. I see them as no different. Oh, and remember also, custody evaluations may also be being used for adoptions and stuff. So they can apply different things in those circumstances if they've terminated a parent. So just keep in mind that what you're trying to do is make sure they're not taking away your authority in a divorce improperly. Okay, so back to this. Custody evaluation, psych evals, home evals, all those things we see as similar invasions of your privacy, as well as when they take those evaluations and they enter them as evidence without you having an ability to defend properly against them, we also see them as a Sixth Amendment violation. So I titled this as what if your child support order is incorrect and they enforce it anyway. But remember, any custody evaluation, psych evaluation, reports from experts, those may be Sixth Amendment violations if this is preventing you from properly defending yourself. Now, Sixth Amendment, they do say applies criminally, but any deprivation of your rights to your child or any enforcement that they're going to make when they've imposed a duty or an obligation on you, if it's a criminal punishment that comes along with it, that is quasi-criminal. So try to apply your Sixth Amendment right. Okay, so let's talk a minute about enforcement of child support, okay? And I'm unfortunately, constitutionally, I'm not really talking to the parents who are saying I'm not getting my child support. I'm talking to the parents that are trying to fight a child support order that was improperly put in place. Okay, so we're not saying we don't want children to be supported. We're saying we want parents' authority to properly be in place because that protects the child first, and then if a parent doesn't want to support that child, that's another story. So we're only talking about fit and loving parents that were never proven to not support their children in the first place. And then a child support order was put in place with the wrong numbers on it, and so now, like in Tina's situation with Ray, they may have a child support order that's based on financial numbers that they never earned. Okay, so what happens if you've tried to show that these orders are wrong? And this order, by the way, if it is wrong and you presented correct evidence showing correct numbers, but they still got the numbers wrong in the order, that is a void order. And I'm going to have Ron explain to you real quick what is the difference between void and voidable.
And so a void order means that it never legally exists. So if a court lacked jurisdiction to do something, if they didn't have any proper authority to act, then the orders they issue are void as if they never existed. And that's crucial because a void order can be attacked collaterally, which means when they try to enforce it, you can attack the underlying order and say they can't enforce it because it's void. Other orders, such as orders that are false based on fraud or or other reasons, maybe they're unconstitutional, but they had jurisdiction, so they're made void after the fact. Those orders existed for a time, and people were able to act on them legally, but the minute they were determined to be void or made void, then they cease to exist. So there's a critical legal difference there when it comes to how you can attack or appeal that order.
Yeah, and I can give you an example of a voidable order. A lot of times people will go in and they'll get a default order, but then the court may find that the other person actually did respond, but they just hadn't recorded it yet. So that order is voidable, and the judge can go in during their period of time where they still have power to correct what they consider an administrative error. They can go in and then void that default order and then put it back on the books to go through the process.
Okay, what about the leeway that a magistrate might have in imputing income? What kind of rights? I mean, they can just take a parent and say, well, I think you're capable of making this amount of money, or I might just think that you have this amount stashed away somewhere, so I'm just going to impute it and I'm going to put it in there, and therefore raising the child support order. They say that's legal, is it?
Well, it's not void, if you will. Statutes allow them to do that. There are ways to attack that. For instance, you can attack the state's authority to impose a duty beyond the minimum reasonable needs of the child in the first place. You can attack on equal protection grounds in that there can be argued that they cannot award child support that as a duty that is different for different people based on their income, right? Because that's an equal protection issue. So, and you can attack their imposition of a duty as a violation of due process, because when they impose a duty, they take away your protection against being put in jail for a debt, and they take away your right to make private decisions about what you're going to do with your life and how much you're going to earn and what jobs you're going to take in your life. And so when they impute you, they are taking away a private right that you have to make the living that you choose to have, and they are telling you that you have to maintain the absolute highest standard you ever maintained for this child. Well, that's beyond the minimum reasonable needs of the child, so there's an argument to be made there that constitutionally they have gone too far. It's a tougher challenge, but it is one that we're getting to and developing more information on.
And Ron and I have been talking about how that possibly may even be a violation of your 13th Amendment, because are they making you an indentured servant? Are they forcing you to not be able to make choices that you want to make regarding how you make a living? Are they forcing you to earn? First of all, that's 13th Amendment. Are they forcing you to earn? Okay.
Yeah.
Second, and are they taking away your ability to make certain liberty choices? What if you want to become a Buddhist? You know? So are they taking those away from you?
And that gets into your First Amendment rights. If you want to join the priesthood and swear a vow of poverty, they say you can't do it because you have this duty.
Yeah.
Right? So there's a constitutional clash right there.
But now keep in mind, your child has to eat, your child has to be clothed, your child has to have a roof over their head. So now if the Buddhists supply it, and during your time that you have them, that's fine, you can do it that way. And also keep in mind that in that most recent case that we talked about in the last webinar, in Ree Sanders, the Supreme Court of Michigan declared that, let's say that you don't take personal possession of your child, but you have not been declared unfit or clear and present danger, you can still decide who cares for your child, who has custody of your child during your time. So if you wanted someone else to care for that child, that would be satisfying your duty.
So the duty also violates your personal right to care for your child, which is a personal and individual right. Like Sherry said, if they haven't proven you if they haven't proven that you failed to support your child, and where they impose a higher than minimum standard of child care on you, they are interfering with your right to make child care decisions on how you want to raise your child. For instance, you may be a billionaire like Warren Buffett or Sam Walton, and you might want to live less than the billionaire style life, and you may want to raise your kids to go to local high school and to live frugally like both of those billionaires did, right? If they had been divorced, the state would have stopped them or made them make different decisions. They would have forced them to raise their children in the billionaire lifestyle. And what we're saying is that is a violation of your basic parental rights to determine how your child is going to be raised and what values regarding money are going to be taught to your child.
Now, remember when we talked about harm earlier today? Now, some of you may be saying, oh my gosh, I did not want my child's life to change when I got divorced, and I'm so glad the court said that, you know, the other parent's going to have to maintain that life for the child. Well, if that's the position that you're in, remember, the courts are violating that parent's rights as well as the child's rights to receive the values and the beliefs of the other parent. If the other parent wishes to expose that child to those changes that the parent wants to make in their life, then that parent should have a right to do so. Changes, remember as well, are not as harmful to a child overall. Now remember, there may be some individual specific circumstances where maybe a child has, you know, Asperger's or something, changes become very, very extreme and very stressful and you know, can create some other things that go on with some different personalities of children, but those have to meet some very stringent standards in order for the courts to say, all right, this, you know, it needs to happen this way. Otherwise, just because it makes a parent uncomfortable does not make it qualify for the state to say that it's harmful to the child and to impose those restrictions on the other parent. So parents get confused sometimes that their discomfort, they think, invokes the power of the state if the state sides with them and goes ahead and imposes something on the other parent. But what the other parent has to know that's being attacked is how to defend their rights. If they don't, they could be seen possibly as forfeiting if they agree to what the court is doing. And I'm going to give you an example because we do have a parent. In fact, there's a parent just this week that brought to our attention that a psych eval was ordered. They chose not to challenge the psych eval until they have a hearing on their constitutional rights, which they have coming up in a couple of months. But in the meantime, they thought it wouldn't be harmful if they just go ahead and go through with the psych eval. Well, it turns out that their order that the court put in place says that it's whatever comes out of this psych eval and from this psychologist is already stipulated to be entered as evidence. Now, stipulated means there is now no more due process regarding that psych eval. So whatever that doctor finds, it gets entered as evidence into the court. So stipulated means you can skip the process of having it entered into the court. And the reason you have a process like entering evidence is so the other side can object, like based on hearsay, based on the report. You know, the report might have, you know, bad findings in it. Maybe they used an evaluation or an examination that is not reliable. So what happened with this parent is this parent went in and asked the psychologist before undergoing the psych eval, what kind of tests are you going to do? Well, guess who got infuriated and offended? That psychologist. That psychologist threw them out and wrote a letter to the opposing counsel, which, guess what, got entered into the court file. There is now a hearing to compel. Okay? There's a hearing to compel the psych eval, but on top of that, remember, the court placed an order that the parent did not challenge yet. They placed an order that anything that comes from the psychologist is stipulated as entered into evidence. So guess what the psychologist wrote in his letter? That this parent asking about the evaluations could be an indicator of a psychopathology. Okay? So what's happening right now is, luckily, this parent's probably caught this soon enough. The parent can now file an objection to the psych eval. And they can file that objection based on a lot of that stuff from the Michigan case in Sanders, that this court has not properly proven the parent unfit or a clear and present danger. Now they are trying to, the other side is making false claims, which is why they want the psych eval from all parties, including the child. But they even put on their order that they're looking for something in the psych eval. Okay, they're looking for things to ensure the safety of the child. But they haven't proven that the safety of the child has been violated. So the parent has to make an objection to these psych evals properly on the record. And when they do, if the court proceeds, then they have to file the mandamus to their appellate court and ask the appellate court to prevent and prohibit, or an injunction or whatever you want to call it, to prohibit the trial court from forcing or imposing any of these things, these service plans, you might call it, these evaluations or interrogations or fishing expeditions, warrantless searches on them before properly proving them unfit. Now, does that mean that the parent asks for a fitness hearing? No, it doesn't. If you read in Sanders, it says that a fitness hearing is the duty of the state. That applies to all states, even though we're talking about Michigan, because they used arguments. These arguments, by the way, are in our book, the same arguments about the parental rights to control custody and care of the child and companionship. And, by the way, they are cases that are from the United States Supreme Court, which is why they're also in our book. So this attorney in Michigan used those arguments. They won. That means those arguments apply to all of you. So even though it came out of the Michigan Supreme Court, what you can do is take that, reference it, use it in the challenge to any orders about psych evals, about home studies, anything. If they did not prove you unfit or a clear and present danger, you can use that and say that these violate the authority of, they violate your rights, that the state has not properly invoked their authority. They cannot use best interest as what Ron likes to call a magical incantation. That also comes from the United States Supreme Court. And he's going to explain to you real quick, what does that mean when the court then backs down and says, okay, well, we're just doing this because we have to determine the best interest of the child, so you still need to do this.
Right, so where this comes from is a case I just recently found, and they use a term that's very similar to magical incantation. It's a little bit harder to pronounce, so I've adjusted it to magical incantation. But it simply has to do with the war powers that are granted to the executive branch during war under our Constitution. And what the Supreme Court said is just because war powers have been invoked, that the executive branch cannot use that as a magical incantation to do away with due process or other constitutional principles. And the case goes on to pretty much tell them that they're full of it and they can't do what they were trying to do. But it struck me that this is almost exactly what the state courts, the divorce courts, are doing when it comes to family law and particularly divorce, where they're using this term, best interest of the child, not in its proper form as what they do when there are no fit parents to make decisions, but they're using it as an invocation to grant them all kind of powers, and that is not how it works. They still have to have proper adjudication and have proper findings that essentially grant them power, or they have to have statutes and they have to have findings that say that they've met the constitutional bar for them to take action. And without that, the best interest standard simply doesn't come into play. And I really like this magical incantation phrase because it's easy to say and remember, and it really cuts to the heart of what these courts are doing. They're just throwing out this magic word and saying, hi, we have all the power in the world and there's nothing you can do. And that's simply false.
And you notice we put here, does this violate your Fifth Amendment right? Because remember, if they're going on fishing expeditions, you have a right to not incriminate yourself. If they're fishing for something, they're looking for a way to deprive you of your rights.
And keep in mind, the Fifth Amendment is not just for those people who are guilty. There are many things that you could be compelled to say to the government that would cause the government to come in and investigate you and tear your life apart with their investigation, even if in the end they would find that you were innocent. The mere fact that they investigated and they dug through all your private information and they searched your house and they did all these things.
And they might find something that they just think, oh, this is suspicious, and
Right.
and they can like twist it out of context and make you appear guilty, put you through a whole heck of a lot of hell and a lot of expense just to find out that somebody just had this stupid idea that it applied somewhere else, and and you're in this mess for years where you could have avoided it by just sucking it up and saying, okay, I'm going to take it. I'm going to take it when they say you appear guilty when you plead the fifth. Well, then you plead it's unconstitutional for you to assume guilt.
Right. So this is very important. The Fifth Amendment, Supreme Court said, applies to the innocent as well as the guilty, but there are some crucial differences in purely civil proceedings and criminal or quasi-criminal proceedings. So if you're in a purely civil proceeding that's about a dispute over property or something like that, then the whole idea that they can't make assumptions based on your silence, that doesn't play in a purely civil arena. They can in that arena.
And remember, children aren't property anymore, they're liberty interests.
Right, so when it gets into this area, which is quasi-criminal because they're trying to deprive you of a fundamental right, then you get enhanced criminal level standards. And that's what you have to know how to say, and that's what's in our book. It talks about when this is purely civil and when it becomes quasi-criminal, which changes the ballgame.
We've kind of already gone over this, so we're not going to go over this one in detail, but it's what should the standard for divorce or child custody suits be, and that's proper due process, okay? And we've talked throughout this webinar about how they get around these standards. And a couple other ways they do it is backdoor behavior. I had someone that I was talking to this week, and in fact, she was going to be on here. She might be on here, but we just don't have time to talk now. She's in Connecticut. She talked about some ways that, they've enhanced the GAL guidelines, GAL guidelines in Connecticut, and how judges have added their own guidelines to get around these new restrictive guidelines and things like that. They play around with these things, and which is why we tell all of you, don't get down in the weeds with them. Do not get down in the rabbit hole, whatever you want to call it. You stay up there where you're protected by the Constitution. Stay wrapped in that Constitution. Keep your head out of, all these little details of opinions and biases and prejudices, and you'll be fine. It'll, it may be stressful still because they will really want to take that power back, but you'll be much finer than if you fell into their traps and their games. So Ohio shared parenting laws, you look at those, you'll find that they found ways to get around those. Again, stick with the United States Supreme Court findings that parental rights are fundamental and natural. Fit parents make the best interest decisions of the child. If you don't remember anything else, you object to what they're doing and you restate that, as well as use the magical incantation argument that Ron just gave you. Stay away from the better parent argument. That's another way that they get you down that rabbit hole. What happens when you don't challenge the fishing expeditions? We just talked to you a little bit about that, about the parent that's facing the psych eval. They want you to feel certain things so you make emotional decisions, like you're not a good parent if you question them, because like Tina knows in one of Ray's hearings, they talked about, this is about the support of your children, and he's like, no, it's not. This is about a bad order you made. But they wanted to make it seem like he didn't want to support his children. So be careful about that. Remind yourself to see those things. Again, those are little biases and prejudices that you get trapped in because you are a fit and loving parent and you care about your child. They're using that against you by using your emotions on it, okay? So they make you feel like you have no authority to question them. If you feel that way, you need to take a break until you can gather yourself again so you can stand there and protect your rights. That's how you battle the intimidations and the threats. So when they try to cost you, make sure you know some very basic things. Your mind You got to trust your brain, trust your mind when you go through these things. Even if you have an attorney, sometimes you have to speak up on your own. So it's not that you need to know all the process and the procedures when you have an attorney. It's that you need to know your basic rights. When you know those, you can also instruct your attorney as to what's acceptable to you and what is not, so that they don't fall into their patterns of, okay, just agree to the psych eval because then you'll get through it. The judge will be more comfortable. Well, you're not there because you want to make the judge more comfortable. That is false belief. That is how you get into biases and prejudices. You're there to propose the right application of cases and laws to your specific case. So if you're a fit and loving parent and somebody's attacking your rights, you're going to propose that your rights are protected. And by the way, judge, here's the authorities that say I can propose this to you. That's it. Keep it very basic. The judge doesn't need to come in and protect your child until somebody proves your child needs protecting. So for you parents that are trying to get your child protected, again, make sure that you have evidence that the state would actually prosecute. Otherwise, you're entering into this horrendous battle as well. It's very, very costly for you and your child. Talk to other parents that have tried to go down that route. Most of them have actually lost their own time with their child. So I encourage all of you to read Santosky, read the Henry Sanders. Authority stating your right to challenge abuse of power can also be found in this 1999 case here, Tenenbaum versus Williams. If officers of the state come to believe that they can never be questioned in a court of law for the manner in which they remove a child from her ordinary care, custody, and management, it is inevitable that they will eventually inflict harm on the parents, the state, and the child. Now, of course, in 1999, this was already happening, right? They were already inflicting harm on the child. Now, they say harm on the state because we won't get into that, but there is harm to the communities of people when they're using resources from the state to attack the parents of the child, and a lot of times they actually take the children from fit parents in many cases. So we're not just talking about divorce cases. There are cases where, you know, charges are brought against both biological parents. They take the child and they didn't use the proper standards, and that child lost the home that maybe they shouldn't have lost. So don't let your children pay the price anymore. Learn what to spend your money on and what to challenge, and sometimes even how to challenge it. I say sometimes because we don't always have all the answers. We research, we try to get them if we can, but we have a lot of answers. We have a lot of strategies that we can teach and that we do teach so that you know how to handle this. When it comes up, you have something else to fall back on other than, oh geez, it's my choice to either do what they say or try to go and dig up evidence on the other parent and prove that they're horrible. So maybe I should hire a private investigator. So all your options are leading to an unlimited need for money to constantly keep the battle going, whereas our options, while they cost a little bit of money, they lead to an end in this. And that's the key. So if you knew there was a way to do this less expensively, emotionally, and financially, would you find that a better investment? We say it is, and if this had been around when we were going through it, we could have cut out years of battling and lots of costs. And I know Mike knows now that he could have cut down what happened to him, and his boys probably would be in his life today if he had known many of these strategies. So how can you learn more to protect your rights and your child's rights? You can go to, you don't need to go to this page, but it's just a pretty picture that Ron made. This is a book on your parental rights and your children's rights in here. It gives you a basic foundation. So a lot of this stuff that we talk about, we did not understand until we put this book together. So reading this book will give you that basic foundation so that you then start understanding a lot of what we're talking about. The other way is you can attend our Parental Rights Academy. We have 3 courses. You learn how to stop giving the courts permission to treat you and your child like a second-class citizen. So if you are trying to protect your child from a parent that you feel is not the best parent for them, then you're going to want to know how to stop giving permission to the courts to take your authority away. You're going to want to know how to stay in control of your life and your pocketbook. You're going to want to learn how to articulate the right solutions to the judge and the attorneys so that your protection of your rights and your child's rights continue. Because remember, in most of these divorces and child custody disputes, they don't end because one of the parents has chipped away at the other parent's rights, and they turn around and they find, well, it worked for me last time, I'm going to attack you again. So a couple of years later, or sometimes even less than that, you're back again. Or they decided they don't like an activity you put your child in, you're back in court again. So no matter what, it becomes extremely costly, and the cost to raising your child now goes up phenomenally higher than what we all thought it was when you saw all those statistics when you were first pregnant or your spouse was pregnant. You had, I know people came to you with life insurance that showed you what the cost of raising a child would be for their lifetime, right? Nobody ever puts in there the cost of court if you got a divorce. So all of a sudden, your cost of raising that child just went up exponentially. So you don't have to go through this in the dark or alone anymore. There is a community here with us where going through divorce doesn't have to mean losing your child. And you'll find that under that fixedfamilycourts.com/product/course-bundle. Or you can just email me. I'll send you the link. You can read more details on the courses. And once you decide which path is right for you, you can contact us anytime, ask us questions as you go through whichever materials you decide you need to help you in this fight. So now I'm going to switch back and answer questions. I know we went a little bit over, but we got started a little late as well. So we're back. Ron, say hi real quick so everybody can see your pretty face. He's over here. He's multitasking. We've got lots of things to work on and different things. I think he's actually taking a break over there. But we've got several people on here still, and we wanted to find out if some of you had questions about the material. If you have personal individual questions, try to keep them short so we can give a quick response. Otherwise, others won't get their questions in.
Since I'm here, I got a short one that you kind of started to touch on earlier, and it may pertain even to me a little bit. Basically, if a parent has already unknowingly been involved in the court system, and maybe even his own counsel has encouraged him to, go with the flow, go with the status quo. Like you said earlier, make it easier on the judge. Don't upset the judge, this and that. So a parent has already unknowingly basically forfeited their rights. They did this without knowing. They figured they're doing the right thing. Now they're discovering that they've done that. They've forfeited their rights. They're having a hard time climbing out of it. They've gotten into psych evals that they don't know if they agreed to or not. Things like that. What recourses might they have right now? What would they go in there?
That's a long question, Mike.
The first thing is a waiver of your fundamental liberty interest has to be knowing and intelligent. So they assume that you know your rights because you have an attorney, but you could turn around and claim ineffective assistance of counsel because your counsel never informed you that you actually have constitutional rights. And it would be nice to see some of these attorneys get sued for malpractice for this. It's very difficult to find an attorney who will actually sue another attorney. So if you can find somebody like that, that would be great, because I think it's clearly malpractice.
Of course, the best option, Mike, right now, I feel that's Ron's answer. My answer would be to immediately put on the record that you didn't know that you were forfeiting your rights, that you're putting a stop to it right now, that you disagree with any avals that they have used in the past. You do not authorize any future evaluations or use of them, and then ask for a hearing on this matter to have all of that stricken from the record. And when you get denied, or if you get denied a hearing or otherwise, then file with the appellate court and ask them to restore your rights based on the court didn't have the authority and you've put it in front of them arguing that they didn't have proper authority and they've refused to restore your right.
You were
do all of that as well.
Yeah.
Very good, thank you.
Gary, there are other questions on here too.
Yeah, I just saw there's a question and I was afraid to click on it yet until we were done. It says to click on it, says, I have asked the judge if I may speak and introduce case law, and I was refused because I have an attorney sitting next to me and was not allowed to speak. We've experienced that before. What should I have done next? Because I'm going in front of him again in a few weeks. Any advice? Okay, first of all, if you still have your attorney, the first thing I would do is talk to your attorney and tell them that if they do not present your rights and protect them, that you are going to speak up. So if you need them for procedural or process things, then what you want to do is discuss with them that that will be their role and that you may even actually have to fire them on the spot in the hearing. Now, Ron has found some things that says that you are allowed to speak, that they aren't just solely speaking on your behalf, even if you have an attorney. So you can put that on the record that your belief is that you do have a right to speak, and that attorney, and I'll let Ron finish the explanation on that attorney, what their role is in your case.
You have the right to represent yourself with the assistance of counsel, not with counsel taking over and doing whatever they want. Now, it's going to be very difficult in family law to find an attorney who will actually go along with this, but if they're doing something that's so egregious, as in a case we're very familiar with where that happened, you can fire your attorney on the spot and tell the judge, I'm going to speak, and I'm going to represent myself, and if I have to fire my attorney right here on the record, that's what I'm going to do, but I'm going to speak, and you're going to allow me to speak.
And then you tell him, and it's not what I want to do, it's what I am being forced to do to be heard.
And I believe that I'm here with the assistance of counsel, not under the control of counsel.
Right. And so you can try that. And again, you always have to be prepared when you are challenging abuse of power. You have to be prepared that you may have to appeal. If you go in there afraid of the appeal, or if you go in there afraid of the time that it would take for the appeal, you're probably not going to stand up for your rights, because they will push as hard as they think they need to push you to get you to give in.
And you can enter the case law in writing. You can supplement your pleadings depending on which stage of the case you're in. You can file certain kinds of motions to get those cases before the court, and you can prepare those beforehand and get agreement with your attorney to file those. But again, a lot of these divorce court attorneys are so used to just controlling their clients and forcing their way over the objections of their clients that you're going to have a tough time finding an attorney who will allow this. When enough people stand up and do this, these attorneys are going to have to stop acting the way they were acting, or they're not going to get clients.
Yeah. So it's not an easy process, but there's an answer for you, so I hope that helps.
You might try younger, newer attorneys. What they lack in experience, they may benefit you in terms of allowing you to do some of these things, and they may be more open to some of these ideas because they don't have 20 or 30 years vested in doing it the wrong way. You have to remember, when you spent 20 years doing something a certain way and someone comes along and tells you you've been wrong, that's a tough pill to swallow, and many attorneys are simply not willing to do it.
Yeah.
Sherry?
Yes.
The chat is enabled as well, so there are a few questions in the chat.
Okay, let me...
Andrew wants to know there's a way to get a copy of the slide deck, and I assured him that you normally record them, and usually everybody...
Yeah, they're recorded in the presentation. So what they were seeing on the screen will be in the presentation. So when I post this on YouTube, you can pause the presentation. But remember, we also stayed on the slides for a long time, except for at the very end, because as you notice, we're not real salesy. We're not here to sell you guys on things. We're here to provide things to you. And if you find value in it, then you'll go and you know that there's a place where you can purchase that service or that material that you need. And in fact, I am going to post those links up here. Here's the course triple package that you can enroll in and click on while we're talking.
So keep in mind, our goal here is to change this system so radically that we're not needed anymore. Right? That when you get divorced, that you won't even really need to go into court hearing to determine custody of your children, because that will be a given under the constitutional rules. The only thing you'll be arguing about, if you're arguing at all, is which days you get versus which days the other parent gets. You won't be arguing about your right to equal time and equal rights at all. So most of this battle will simply evaporate and go away. Now, for attorneys in family law, that's potentially a bad thing, because they're going to have to find other ways to generate revenue. And for us, it's a good thing because we will get to find other ways to generate revenue.
Hey, Sherry.
Yeah.
Cynthia's question is, this all applies to just a custody battle, right? It's not a divorce issue. And how did you, or why did you get involved in all this?
Okay, the first part of the question is it applies to both divorce and custody battles. It applies to parents that have never been married. You can look at the case called Stanley where it says that never been married parents have, or single parents have rights. There are many, many cases on never been married parents. This applies to modifications in child custody which occur after, long after sometimes a separation or a divorce.
And one of the things we're working on getting a clear statement from the Supreme Court, and they're very hesitant to say this, but we believe you have a First Amendment free association right to get divorced. And if that's the case, then what is very clear is the state cannot punish you for exercise of a freedom of, an exercise of a fundamental right. So if the right to divorce is a fundamental right, then all of this stuff that the state is doing that is basically punishing you for that First Amendment choice, they simply are not allowed to do.
And some of my personal feelings are because we're not saying we're encouraging divorce, but my belief is that if we make it so that states can't be so lucrative on divorce, then perhaps they won't be encouraging so many of them so quickly. Because I think sometimes people go to divorce attorneys just to find out, you know, just to kind of inquire how would things be if I get divorced, and they get enticed.
Right. So our divorce laws today are basically set up based on 19th century principles, where women were unequal and unable to support themselves, and men had to take on those duties, and a number of other principles, children as property, those kind of things. Yeah. And what we're trying to do is convert this to a 21st century system based on 21st century principles of equality and free choice and free options and much less state control over your life.
In which really it has been converted when the 14th Amendment got passed, and then they had all these cases where they ruled that parents' rights are fundamental. What hasn't converted and what hasn't kept up are the cultural beliefs, and that's where you come in, where you individually can do this for yourself right now. It's just not as easy as if this had already been done multiple times and the states gave up now. You know, like when states were reluctant to desegregate schools, they had to really, you know, people in the states had to put up a fight to exercise that right, even though they had been told they had that right. So what we're telling you is you have these rights, and you're going to have to put up that fight still. That nobody, you know, the federal government eventually did step in to assist with the desegregation. And perhaps maybe they will on this someday. It depends how bad it's going to get.
We forget how much earlier generations had to fight. When I was a kid, one of my aunts got divorced, and she used to tell a story when there was only one phone company called AT&T, and she was, as a divorced woman, tried to get a phone in her apartment. They would not deal with her. They kept telling her to go get your husband and have your husband come up here and talk to us. We're not going to work with you. And she had to fight, and I mean fight hard, to get the phone company to install a phone in her apartment because she was a single woman. And this wasn't all that long ago. I'm not really that old.
And now remember, none of us have had to do that, right? So that's what we mean by some of us, just enough of us have to fight for it. That doesn't mean thousands of people or even the marches on Washington. While those are very helpful in raising awareness that there's an issue, it's each one of you have the power now, every individual person. And so I want to put this up here real quick too, because I mentioned Reed Santosky. So I just put that up there where you can click for the case on Santosky. I don't have Sanders up here. If you want Sanders, email me, because I do have it on the website, but it's hard to get to the page. So email me if you want Sanders, if you can't find that yourself.
So this is a little bit like the emperor has no clothes. They know that what they're doing is unconstitutional, and it just takes a few of us to expose this in the right way before everybody in the crowd starts looking at it and say, you know, this isn't right. And once everybody does that, then it just goes away.
Yeah. And I believe there was a second part to that question, Tina, where she asked, how did I get involved in it, or me and Ron? So I'll answer my part real quickly. We went through it. We went through several years of battles.
Several years, quite a few more than several years.
Yeah. So we both went through it in our own battles, plus together. Plus, we've always had a strong sense that we make our own decisions and that we had authority, and we were constantly fighting the courts in this way. We have both prevailed. We both share. I want to call mine equal 50-50 custody, but he lives in another state, but he does get all summer and all the holidays. He also can get 3-day weekends, but also since this contentious arena was removed, you know, he knows that anytime he asks or needs that, you know, we work together now on it, whereas that nobody that knows us or even lives here would have ever thought was going to be possible. There was never a time that we spoke and it wasn't an argument, a fight, a heated dispute.
We went through pretty much as bad as it gets. And we went through it for a very long time. And we won through tenacity, through application of strategy, and pure just determination and fight. And once we won and we had some breathing space, we knew all along it was unconstitutional, but we didn't have the breathing space to go and figure that puzzle out, because it was a big puzzle. But as soon as it was over, we sat down and did this and did the research, and we expected it to be a small little book saying, yeah, parents have rights. It came out to be over 300 pages.
And the reason he calls it a puzzle is that it still has pieces that have been falling into place, which is a lot of the reason we do the webinars. There was only so much we could fit into the book, and we still research this stuff every single day.
We had so many biases and beliefs that are cultural that most people share, that they were major barriers to us understanding what was really going on. Once we broke through those barriers, we were able to write about it, but then it takes a little bit of time for your brain to really wrap itself around the fact that you've changed your biases. And, for instance, the equal protection argument, I've said this over and over again, almost didn't make it in the book because I couldn't figure it out. What's in the book is good, but since then I've condensed it down to a very succinct, easy, quick argument that just about anybody can figure out in 15 minutes and tell to their judge. And it's on the website, completely free, on the main menu under equal protection. It cites all the cases. That alone should be enough to overturn this apple cart.
Yeah.
Did you guys represent yourselves from the start, or did you have counsel?
Not at the very beginning. We both went to an attorney. That's what we thought we were supposed to do. They're the ones that made both our cases an absolute mess. In fact, if Ron had stuck with a female attorney that he had originally, he would have ended up paying for all kinds of ridiculous discovery that the other side had asked for, depositions.
And I wouldn't have gotten equal custody, equal time with my child. There's no way she would have tolerated that.
She had him agreeing to child support, alimony, all kinds of stuff. It wasn't until he changed attorneys that he started to realize, wait a minute, how can these attorneys be doing things so differently? And the other attorney just slammed it, shut everything down.
He basically raised Fourth Amendment search and seizure arguments against the discovery, and the other side never countered it. And so I never filed one piece of discovery paperwork, not one.
Yeah, and so then after that, I ended up representing myself most of the time. My battle was much more difficult. It was 4 children. All of them are 3.5 to 4 years different in ages, so they were all over the board in age. And my battle was just, they called it a train wreck. They said it was one of the worst battles in the history of our county. And I ended up having to do most of that on my own. I went completely broke. I had very successful businesses up into the 6-figure area. We had a home in the country club that foreclosed. We lost everything. So it was I'd say everything I see everyone going through, I've probably experienced little portions of that, if not all of many of what people are experiencing, which gave us a very detailed insight into a lot of this, but I did most of it on my own. There were many hearings where Ron was even out of town, and I had to attend the hearing myself, and I guess because I was by myself, many times most of the people in the courtrooms assumed that I was an attorney. Because
she stood up and told the judge no. He wanted to do something. She said, no, I'm not doing it.
I mean, sometimes that was the simplest thing for me to do before, and I've told people this many times, before I walked through those doors, I told myself, the worst thing has already happened to me. I don't have my children, so if the judge wants to throw me in jail, I will continue my fight. And so I walked through those doors without fear of retaliation from the judge, jail, or anything else, and I knew that I had to stick to what I believe my rights were. I had limited, we spent days and days in the law library reading cases. That's where we started to get these ideas that there's fundamental parental rights.
And this was before the days of Scholar Google. That didn't exist at the time.
Yeah, we were
or if it did, we weren't aware of it.
We were in the law library, and I had disabilities as well. I don't drive myself anywhere. That's part of what I ended up with permanent from the post-traumatic stress of all of this. I ended up, after being an extremely independent person, surfed when I was a teen, drove all over the place, had multiple businesses, just did all kinds of things on my own. I no longer drive by myself. I have panic attacks on the road when I do that. They actually tried to use some of that because they said, wow, well, you have the ability to read all these cases and do all this work and file all these motions, right? So they always want to make it appear like your disability doesn't hinder you from getting proper representation, but your disability might be a factor in not caring for your children properly, right? They didn't quite ever go there, but I know that's where they were trying to go, and I just didn't ever let them. So I knew, like he said, I had strategies, but from working with Ron, because Ron wasn't being as emotional as I was. He had his emotional connections because it affected his relationships with my children, which were his stepchildren. But we were able to put together strategies, and he would tell me all the time, strategy takes a little time, but once it works, people fall like dominoes. So we had a lot of success afterwards with people who abused their power losing their jobs as well. We did not sue any of them. We did not file charges or complaints against any of the people in the courts formally. Now, we did file against some city people directly. So anyway, so to shorten this up a little bit, we went through it. That's how we got into this, and I think we have unique perspectives because not only was I a researcher before I got into this and Ron was a business strategist, but we have the personal experience and the ability now to see beyond the biases. So that's how we help all of you.
The biggest thing in all of this is recognizing the societal biases that we have, the things we think that we take for granted, like the idea that there has to be a primary parent. There has to be one parent where the kid stays with most of the time. Where does that come from? There is absolutely no basis for that whatsoever, other than the idea that we used to have kings and the men used to be the head of the household, the king of the house. Beyond that, there is no basis for that presumption whatsoever, and yet we all just fall into it naturally. Certainly every judge and every attorney does.
I need to answer a question here. Ron will talk forever, by the way, if I let him. We probably both will. Okay, Dan. Dan has a question. He's not sure if it's off topic. He was losing connection issues on his end. Is it possible to be successful in applying any of this in a modification? You said, I actually do not want a modification. I want a do-over so I can have my rights back that they stole in the first judgment. First of all, yes, of course, we did mention, but you might have lost connection, Dan, that this can be used in a modification. Second, Dan, I'm not sure why you want a do-over, but I can guess that's probably because you didn't know your rights when you went through it. Whether or not you can do I don't know what you consider a do-over. However, there are different strategies that you can employ to try to get your rights restored. Many times the modification seems to be the route that they like to choose, but there's lots of things that you can evaluate if there are violations of your order. And if you're in Texas, a lot of times we'll recommend strategies like filing just enforcement of the order before you make that modification or file that, because, and you have to kind of do them, you have to time this right, because without a modification you can't change custody, but if you enter a modification first in Texas, there's no more parental presumption. You end up opening this big door of possible abuse of power. So there's just a lot to look at, Dan, which is why we encourage people, learn your basics of your rights first. If you need to get some of our one-on-one help, you do that. If you take a course, you start understanding this stuff on your own. And we interact a lot with the students that are taking courses, because that allows us to have that more consistent and constant interaction with you guys so that you can start actually practicing this material. That'll make you able to use it. That's the important part, is we can tell you over and over and over again about this, but you are the one who has to use it. So you have to practice it, and you need people to practice with, and you don't find very many that really have this kind of deep understanding. That's why I encourage people, if you can, get in the class. If you can't afford that whole course lump sum, contact us. We can send invoices out and break it down into payments. I will tell you absolutely every parent that's taken it so far has told us that they see the investment value. They have saved themselves tons of bad decisions which would have cost a lot of money, so they've saved a lot of money. So look at it from the perspective of an investment and how much you will save. Thanks, Dan. I appreciate it. So if there's no more questions, we're going to end this webinar, because I think I just told Tina that I was getting really good at holding them to 1 hour. Sorry, Tina. And Mike, as always, we appreciate you coming. We know that it's really hard on Mike, as Mike has gone through years and years of struggles. But I think, Mike, you're starting to understand a little bit on how to get yours moving again, right?
Yeah, I am. I mean,
Okay.
if people out there, you know, they wouldn't know, how would they? But I've been doing this for, you know, it's going on off and on for a decade. It's the tail end. My kids are aging out of the system. Over the past, you know, it's been less than a year that I've known you guys, and what I've seen so far and learned and attending these webinars, it's just been almost overwhelming. I mean, if I would have had an inkling of what you guys are teaching back in the beginning, it's very, very, very important for you to preserve your rights right from the start. Do not give them up at all. No compromise. There's no reason to. It's all right here with what Sherry and Ron are saying.
Yeah, so it's very important what Mike's saying, everyone. You've got to get this resolved as quickly as possible. If I had known these techniques that I just brought to you guys in the last 2 webinars alone, I could have reduced the time that this was going on, and one of my children wouldn't have aged out. One of them was already almost 18 when the divorce started, but there was another one, the second oldest one, that aged out of the process. So if I had known this, I could have gotten this into a position, if I had known to challenge that I wasn't unfit and I wasn't a clear and present danger, if Enrich Sanders had been around, and if I had understood these rights and all of the basic foundation of these, which, by the way, doesn't take all that long to learn. I know I have listed it's 12 weeks and 8 weeks and 8 weeks for the class. Once these classes are fully developed and you pay for them, you can get the whole course all at once. So pretty soon, once they're developed, we'll let everyone know when that happens. Then if you go, oh my gosh, I didn't take them before,
you'll be able to take them as fast as they'll be available to you, so you'll be able to take them as fast as you can absorb them, right? So right now you have to get the first class is already there, so if you want that and want to absorb it as quickly as you can.
We've already got, what, 5 weeks of that one up, and that's on the basic foundation.
Well, no, the second class was completed first, so the second class, you could pay for that today and take it as fast as you can sit through it and absorb it. As soon as the current class is complete, then you'll be able to do the same on that, and then there will be another class after that. But right now, this first class, the second one we've put together, is in development, and we're just about halfway through now.
Can I say one more thing? One more thing. Take what you can out of these teachings and what you learn. Use what you can for your own case, okay? And then keep learning and tell others, teach others. Just make this the norm. And basically, it might sound far-fetched from now, but make this the norm in society. This is what people need to do to change what, you know, this system is doing to us and our families. It's very important
for your children.
Yeah, because your children will be very relieved if they find that you've got this fixed and they're no longer being used in the middle. They're no longer having to go through a bunch of evaluation. I know a lot of people say, but my child wants to be heard. They want to be heard. And you'll say, yeah, they want to be heard, and they'll agree with you, but what they're not understanding is how much stress and damage and guilt that's going to build up on them later. And what you may not be processing as well is that children are going to go through periods of time where they're not going to like one of you or the other of you, and those are things they need to learn to get past. And if they can't work through things with that other parent, and again, we're talking about fit, loving parents, okay? If they don't ever get the opportunity to work through something with that other parent that they experienced, then that may be a wedge that ends up there that not only hurts that child, but hurts the relationship with that child and that other parent for a lifetime.
It may impact that child's relationships for the rest of their life. They may get into a situation where they never learn how to work through these things because they didn't do that natural process with their parents as they grew and their worlds changed and they started seeing their parents differently. They never learned to work through that process. They never learned that relationships that survive over time have to change and adapt.
While you may think you are protecting your child, you may actually inadvertently be hurting them. And you may be doing it out of the idea that you protected yourself by getting out of the relationship with the other parent. And that's just another bias that you're going to have to get beyond. So there's a lot of biases and prejudices that you'll actually find pay off for you to get beyond and past, and it will help your children not be in the middle. We appreciate all of you guys attending tonight. We're on. Do you have one more thing to say? And
just keep in mind that just because you fight with your spouse and you believe your spouse is horrible doesn't mean when your children are alone with your spouse that he or she is a bad parent. They can be a wonderful parent, and what you experience when you're around them may just be a reflection of the state of your relationship with that person, and not a reflection of their parenting desires or abilities.
And that doesn't mean that they make all the decisions that you agree with or that you like or that you even think are great. That just means that your child may have a relationship with that parent that you shouldn't be getting in the middle of and you shouldn't be destroying. And you should probably be supporting that child having their bonds in the relationship with both parents, even if you don't like them. So keep that in mind, and we hope we got everyone's questions answered. I appreciate all of the advice you gave the parents as well, Mike, and all of your help tonight, Tina. And we hope to see all of you guys next time in the next webinar. Talk to you next time. Bye now.